They call her the cat lady. People say she's crazy just because she has a few dozen cats. But can anyone who loves animals that much really be crazy?
Any objection to bringing these matters together?
It's really a moot point, Mr. Chair. I have just informed the clerk that we are withdrawing our objection, and so we don't need to even be heard today.
Okay, so, I just want to put it on the record then, that Jonas versus Andreas is withdrawing their objection.
That is correct.
Okay, so we will move forward with Latham versus Andreas.
Thank you.
Are the parties with the council present? You can identify yourselves, starting with Ms. Andreas.
I'm Linda, Linda, Andreas, Andreal.
Okay, your turn.
John Hanson, John Hanson, appearing for the candidate respondent.
Harold Lee Watson Jr., Harolwathan, Thomas Baxter, Mr. Walton, and Julie Lucci.
And do the parties intend to call any witnesses today?
Yes.
I'd like to confirm for the record all the documents the board has received. We have the nominating papers of candidate Linda Andreas, including the statement of candidacy, the loyalty oath, 87 pages of petitions and nomination, pages 74 and 76 are pulled from consideration. Statement of economic interest, receipt for filing campaign papers, and receipt for campaign disclosure materials received. I'd like to enter that into record as well versus Andreas.
No objection, but I'd like to clarify something with the council needs. Are you indeed withdrawing the petitions from the packet 74 and 76, which were petitions for Babcock? That was the basis upon his refusal. They were contained in Ms. Andreas's petition packet. Notice here that you're withdrawing them. Are you withdrawing them, or should we consider whether or not we need to strike those on our own?
No, if you would strike those on the motion and the conclusion as well. Mr. Chair, I do have for the board a board brief on applicable law I'd like to provide to make part of the record.
You'll have nothing with that. Just for the purposes of clarity, because this does say they were withdrawn, they're not in fact withdrawn. I think on the basis of, but no, that was what we were considering might happen. Maybe not. The basis for Treasurer Babcock's refusal and the true presence here was the fact that it appears two petition sheets for Babcock were contained in Ms. Andreas's petition packet. That was not raised as an objection by objection, but due to the fact that it caused the recusal of one of the board members, I think it's appropriate for this board to raise it on its own motion, sua sponte, and strike those two petition packets and accompanying or to strike the signatures from those pages from consideration in Ms. Andreas's total. Those are, yeah, go ahead.
If we are allowed to do so under the normal election code, we have that problem of drawing those two pages.
So you would withdraw?
I don't object to them being withdrawn.
You're floating into a region where you're attempting to raise an objection that wasn't raised, so.
Which the board can use sua sponte if it absolutely needs to. In this case, the only reason why we would is because it caused the recusal of a board member. But as you stated now that you'd like to withdraw, I think it's sheet 74 and 76 from consideration, or at least withdraw the signatures, agree to strike the signatures from those pages. which for pagination purposes would make the pagination, continuous still. And I think I would agree with that. If we vote on agreeing to strike the signatures from page 74 and 76 from Mr. Andreas' total.
And to clarify, instead of 87 pages, there'll be 85 pages.
Well, there'll still be 87, we won't count the signatures from 74 and 76.
Are you okay with that?
Yes.
Mr. Mayor?
That's fine.
I'll say.
Second motion, all in favor?
Aye.
Alright, so that's, for pagination purposes, they're still there, but for the purposes of counting those signatures for Ms. Andreas, they are not counted.
We have the objector's petition. I'd like to enter that into record as Watham versus Andreas Exhibit 2. You vote on that?
No objection, none.
All in favor?
Aye.
We have duplicate copies of the nominating papers of candidate Clerk Andreas, including the statement of candidacy, political deal, 87 pages of petitions for nomination, statement of economic interest, receipt of filing campaign papers, and receipt for campaign disclosure materials received. All of which were provided with the objector's petition. I'd like to enter that into the record as Watham versus Andreas Exhibit 3, with the so noted changes. Objection? All in favor?
Aye.
We have a call issued to the parties. I'd like to enter that into the record. Watham versus Andreas Exhibit 4. Objections?
Objection.
All in favor?
Aye.
Anything else?
Board.
Are there any other documents from the parties that have been filed and that it did not list? Mr. Hanson?
Yeah, true appearance.
We have
We had that. Very good.
Other than my true appearance, no.
Okay. Are there any preliminary motions the board needs to consider? Anybody here or Mr. Hanson, Mr. Mack?
No.
Okay. At this point, can the objector confirm his or her residential address and whether the residence is in the relevant political subdivision? Give the objector standing to bring to the subject.
203 West Main Street, Collinsville, Illinois, 65224, Simon County.
Any objection, Mr. Hanson?
No.
We will proceed with the hearing at this time. Objector, you will have reasonable time to present a brief introduction of your objection, present any other evidence, and call any witnesses. Because this is an expedited proceeding, we'll start with an initial time frame of 15 minutes. Stand by to swear you in.
Sure.
Raise your right hand. You swear the evidence you shall be given to the court in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. You state your name, please.
Harold Lee Watson Jr.
All right, and, did you come to review the, election nomination petitions for Linda Andreas?
Yes,
And what was Miss Andreas running for?
county clerk.
All right. And when is the election for that? Generally? What year?
This year, or excuse me, 2026, next year.
Okay. Did the election forms require the listing of the date of the election?
Yes,
Did her nominating forms mention anything about any election in 2026?
no,
Did they mention an election in 2025?
yes,
Had that date come and gone already?
yes.
Are there any other objections that you have made to her nominating petitions?
No.
I'm happy to do the cross-examination or make argument.
I have no cross-examination requests.
Some of my arguments is that it is a mandatory obligation to place the correct election date on the nominating petition. While the election date, understandably, might sometimes not be perfect, for instance, it probably would be a de minimis violation if she put the month of the year. She didn't put the correct year. It causes confusion to the persons signing the nomination, to the public in general, to the wrong year on the election nomination proceedings. Signed Waller versus Municipal Officers Electoral Board, 28 Ill App 3D, 823, point site 829, statement of candidacy referencing the wrong election date, rendered papers totally lacking the essential elements required by the legislature. In Gerard v. Keith, 341 Ill App 3D, point site 907, incorrect election date on petitions are independently favored. In Hicks v. St. Louis Board of Elections, 2015, 118929, paragraph 26. The Illinois Supreme Court said there's no substantial compliance reported defects. Strict adherence to avoid undermining voter intent. I can go on with additional similar citations. The bottom line is this: the date of the election, the year of the election is critical. Without at least the right year of the election, the nominating petitions are null and they should be stricken. Without the nominating petitions, without the correct date on there, there are insufficient signatures, and therefore the candidate should be stricken. That's part of the argument.
Do we proceed with candidate?
Yes.
Okay.
Thank you. The policy of the state is to favor ballot access of candidates for public office. Access to the ballot is a substantial right that is not to be denied lightly. To do so is to guard the rights of voters to nominate candidates of their choice. And to do so, candidates are to appear on ballot for election except in circumstances of violation of mandatory provisions of the election code. And these are not just good statements, they also happen to be case law of the Illinois Appellate Court. I have a brief on applicable law I'd like to provide the board before I continue with my argument. Sure.
Our legal meeting agreed evidence with the board. Receive it for its own.
Mr. Chair, may I approach the podium, please?
Just, take it.
I already
Just gave you a copy.
John should have done.
I know you're jealous that I provided that to him first.
Mr. Hansel, go into your official, nothing else.
That attention to detail.
To address the board, this is not even a matter of substantial compliance with the election code. This is the objector attempting to create a requirement that does not exist under the election code. Section 10-4 of the election code controls nominating papers. Our appellate court has already made a decision in a matter very analogous to this case. Specifically, there is no requirement in section 10-4 of the election code that requires the date of an election. If you would, I'm going to go ahead. We're going to take a look at the actual election code again. projector is actually choosing the function.
It's not working. We have your brief though, so tomorrow we'll have that.
Very well.
I want to persuade you to use yellow, John, please.
Please go back to playing professor. Well then, perhaps always having a backup. I'd like to approach with a copy of section 10-4 of the Illinois Election Code, if I may.
Professor Conway, I think you have a share.
I got the fuck out of town. It's a copy of the first page of my client's nominating petitions. And I'll note, personally, I can pretty safely say, have reviewed tens of thousands of petition sheets over the last 10 years. And while this is in fact a form that is provided by the Illinois State Board of Elections, and all of the nominating petitions I have personally reviewed in the last 10 years make use of this form. Guess what? Illinois statute does not actually require the use of the State Board of Elections form. But what does it do? Well, it provides that such petitions shall consist of sheets of uniform size, and each sheet shall contain above the space for signature an appropriate heading giving the information as to name of the candidate or candidates in whose behalf such petition is signed, the office, the party, place of residence, and such other information or wording as required to make same valid, which that would be referring to whether or not you must clarify, is this state of Illinois office, is this a county office, is this a precinct office, and the heading of each sheet shall be shall be the same. Not only can you see with your own eyes that there is no requirement in the shall consist language of the date of election, but in fact, the appellate court, in reading this, has stated exactly the same thing. And included, which this is on page 2 of your briefs, the last paragraph, is that if it were to include anything else exhaustive, that the election code would be amended to reflect that. Moreover, the Illinois Appellate Court, in Wiggins v. Rogers, indicated that nominating petitions that include a date that is not the primary election date is not a violation of the election code. And in that instance, instead of a merely de minimis scrivener's error, placing this year instead of next year, which I hesitate to think how many people have not done so on a check or a scheduling order or anything of the like. In that instance, well, you know what, the candidate actually attempted to list only the primary election date, which was not in fact the office they were running, or pardon me, not in fact the election in which they were running. And I have copies of that case law as well. Board compliance.
So I also have a copy of Wiggins' case, which, Council Mag, I did not reference, but I think is interesting for this case. In that case, you have an individual, as Mr. Hanson was saying, who filed nominating petitions that indicated, as in this case, that indicated that the petitioners were seeking, so for example, in Linda Andreas' case, do hereby petition that the following named persons or persons shall be candidates of the Republican Party for the nomination election for the office or offices hereinafter specified to be voted for at the primary election to be held on March, and then this is where the date is wrong. But the petition says specifically to be voted on at the primary election. So in the Wiggins case, my reading of that case is the same exact thing happened there. The petition said, petitioners who had signed the petition, that's what it's about, were requesting that this person be added to the ballot at the primary election, and then the date was wrong. And so in that case, the court said, this is just based on our research, quote, thus notwithstanding the inaccurate date entered, the petitions did specifically request that the petitioner's name be placed on the ballot in a consolidated primary election, the date of which was set by statute. So what the court then concluded is that there is no voter confusion. That date did not affect the clarity of the request of the petitioners to be placed on the ballot at that particular primary election. Had there not been the phrase at the primary election, maybe there'd be some question about what election they're seeking to be added to. But the court's Wiggins indicated that the directive by the voters to be placed on the primary election ballot was clear enough, didn't have any confusion. And they talked about the Waller case that you referenced, which is a good case for you, but they distinguished that case. And they said that Waller was primarily decided based off of, the completely inadequate statement of candidacy. There were multiple reasons why that candidate Waller was kicked from the ballot. And it was the reason why they indicated was because of a very inadequate statement of candidacy in addition. So they distinguished Waller completely. They reference it, they discuss it, they distinguish it, and then Wiggins says basically, as long as the voters clarify which election they want that person to be on the ballot for, even if the date is wrong, that's not enough to overturn the substantial interest in having ballot access. That's what the Wiggins case says. So, do you have any response to that?
Yes, under the logic in that case, one could literally write up a random date for an election and proceed to garner signatures for elections into the future and stockpile them. And as long as they didn't get notarized, there would be no way to know that they've been stockpiled in the past. The purpose of putting the election date on there is really twofold. One is to let nominators know when the election is. Two is because there are deadlines imposed for filing these nominations. And that the signatures cannot be gathered before a certain date. If we take it as true that these signatures were gathered 90 days before the date of the election, or whatever the magic date is, then these signatures are either invalid, being stale, or they're invalid, it is not being right yet. The purpose of the requirement to have the data there is to eliminate confusion, prevent voter fraud, prevent nomination fraud.
Let me ask Mr. Watson, do you believe that any of these signatures were gathered before March 17th of 2025?
I have no way.
Do you believe that?
Well, actually, the real question is whether or not you believe that there are any of these signatures that were collected outside of the circulation period.
How would I know dates aren't right.
Well, we have Ms. Andreas here, and I assume that.
Well, then she would be the
Put her
person
on
who made
the-
this. Yeah.
We could put her
I
on
would have no way
today.
of knowing that. I can't tell from the petition limit.
Right, I think, Mr. Ryan, you can put Linda under oath today when she's here as a witness, and you could ask her if any of these signatures were collected outside of the circulation date.
I think that's an obligation for the respondent to the objection, not the objector. I do know that Ms. Andreas was collecting dates after the first day of filing. I mean, I don't know how long after that she was collecting dates, but I do know she was collecting dates then. And I'm not aware of anything in what she ultimately filed that indicated that a correct election date.
Yeah, objecting that one, this is not within the boundaries of the objector's original objection is filed.
I tend to agree, I'm just answering the question.
If I may have a brief rebuttal to Mr. Mack's previous statement. And I will agree, there is in fact direction, and it's contained in section 10-4 as to the period under which objection, or pardon me, petition signatures may be acquired. You know what date is not in section 10-4? An announcement as to when the election date is. It's not required in the unnominated petition packets, which is why the court in Wiggins ruled in the manner in which they did. And moreover, all of this makes sense because, you know what, the legislature provided us with the election dates. That is a function of statute. It's completely out of the control of the candidate themselves.
The argument would be akin to saying you have to number your petitions, but it doesn't particularly matter whether you put the 1, 3, 12, 10 as opposed to 1, 2, 3, 4. The nominated
says sequentially.
those are sequential. It doesn't say immediately after others. Those are sequential.
Do you know if we've had any recent elections where dates were wrong, that this board has voted to allow on?
I don't know of any, but this Wiggins case is from 2019. And so it's the most recent case, and it's, in my view, it's pretty much ground. The date stated in the petition was wrong, but the petition did state that the voters on that petition were seeking at the next general primary election. There's no allegation that this was collected outside of the circulating period, that all the other dates are correct, the circulators, the notaries, everything else. The only question is whether that, which under this allegation, mistake, nobody's saying that this was actually done in March of 2025. They're just saying the date's wrong. And so the question is whether or not that error, scrivener's error, potentially, in the date is sufficiently grave to cause voter confusion or to overturn substantial compliance. And Wiggins, I think, finds the board because it concludes that the failure to put the correct date or the even putting the incorrect date, as long as you have the other parts of that petition heading, is substantial compliance with the code requirements. So in my view, this case governs.
If the board believes that case governs, then obviously it's for a higher authority to address that.
Right.
So some of the.
Thinking out loud.
Please do.
So can I ask the attorney, Ms. Andreas, if can we ask her for the attorney if she obtained any signatures prior to March of 2025?
I think we could. I think that Mr. Hanson had also pointed out that whether there's no allegation, the objector's not even making an allegation that happened, so you're just seeking
Right,
clarity.
I'm just
There was a
curious
mistake,
because
not
if not,
prior.
then, was there any attempt to deceive any of the 87 or 85 pages that are valid
Right.
other than that date?
Right.
And since Mr. Watson is unable to have an opinion, which I understand where he's coming from, the other angle would be to ask Well, I think I'll just say the allegation is that, could you stockpile these sheets?
Right.
Right,
So the only person who could answer whether or not there was an intent would be the candidate.
right, that's a valid question.
And without asking the candidate, we don't know that.
I think we can.
So I'm thinking out loud for the attorney.
We can ask the candidate, let's,
Swear me in.
Please stand. Raise your right hand. Do you swear that the evidence you shall give to the court in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God? I would like to ask you that based upon these signatures that have the date of March 17, 2025 on each petition, were you trying to deceive the people that were signing these sheets, and or were these petitions obtained, the signatures obtained prior to March 17, 2025?
The signatures were obtained after August fifth of 2025.
What date?
August 5th of 2025, which is the date that you can begin
Okay.
circulating.
And more specifically, were you trying to deceive anybody by
Absolutely.
putting the date of March 17, 2025 as the election date?
March 17th is the date of the primary election, of 2026. So one digit.
But my question is, were you trying to deceive anybody by
No.
putting March 17, 2025 on the petitions?
No.
was it just a mistake?
Yes.
Okay. Was anybody in doubt when, at least for the ones that you circulated, which are not all of them, but the ones that you circulated, were any of these people in doubt as to which election you were attempting to get on the ballot?
No.
Okay.
I have nothing further. I have no questions.
If I may, did you circulate all of the petitions?
Did I circulate all the petitions?
Oh,
I had other people circulate
Were you present for all of the signatures?
for all of my signatures.
For all of them that were not yours?
Was I present for all the signatures that were not mine?
I'm not objecting, this is outside the scope of the objector's objection.
Perhaps, but it's entirely within the scope of what was just asked by the board.
Not sure. if that's my question.
Were you present for all of the petitions?
Every circulated petitions for me, they had their petitions, they got the signatures, they got the names.
And you weren't necessarily present for all
Same objection.
of them. Is that accurate?
I couldn't answer. I just
You
said.
can answer on this logic.
Okay. I mean, I don't know how else to answer that, what I just said. You have circulators that circulate petitions for candidates, so I had circulators.
Okay, and my question was, you weren't present for all of them when they were signed by the nominators, correct?
No, how could you?
So you don't know whether they were confused or not.
No.
Same objection.
Correct.
I doubt it.
You're guessing.